That's appropriate, Mr. Spinner. I'm just going to ask you one request is to mute your microphone while Mr. Sierra is doing his argument. Very good. Thank you, Mr. Spinner. All right, Mr. Sierra, we are ready for your case. And so as I begin the clock, how much time would you wish to reserve for rebuttal, sir?
5 minutes, Your Honor.
Very good. And whenever you're ready, please proceed, sir.
Good morning, Your Honors. May it please the court. My name is Nelson Sierra, and I have the pleasure of representing the appellant, Mrs. Layla Strandberg. This court should reverse the trial court's judgment, granting summary judgment for 2 reasons. The stairs in this case were hidden behind a closed door, therefore were not open and obvious. And second, the trial court abused its discretion in granting summary judgment on the motion for rehearing without taking the expert's affidavit into account. Because this is a motion for summary judgment granted, the standard of review is de novo. Turning to the first point, the stairs in this case were behind a closed door and therefore were not open and obvious.
And Mr. Sierra, would you agree with this proposition that the law is fairly well settled, that that a difference in floor levels really doesn't itself constitute failure to use due care for the safety of a person invited to the premises, and there's no duty to warn when it is obvious and not inherently dangerous? You agree with the case law with respect to that?
Yes, Your Honor, as long as it is obvious.
Okay.
Open and obvious is the point.
Which leads me then to my next point. So considering what was presented to the court, we see the pictures of the stairway that's in the record that was provided to the court. We have heard your client's testimony. What evidence did she present in any way that the stairs itself were defective?
Well, Your Honor, it's because they were behind a closed door. They weren't expected. And also, two, it's the genuine issue of material fact is, one, it's behind a closed door. Two, it's also a door that leads to a restroom. Reasonable people can come to different conclusions of whether or not one expects to find stairs when going into a public restroom. Then the third is the amount of inches that the industry standards dictate of how.
So that's your expert's affidavit. Let's talk for a minute about the summary judgment, the burden that how that went, right? The Hokies moves for summary judgment based on your client's testimony, among other things, that she wasn't looking exactly where she was going, and relies on the legal principles, including what Judge Kazan just argued. At that point, then the case had been pending. I think the motion for summary judgment was filed 8 or 9 months before the hearing. Your client, under Landers and the supplemental authority that the other side recently filed out of the first DCA, not a controversial proposition, once the movement demonstrates non-existence of a genuine issue, and they're not required to negate all potential possibilities, the burden was on your client to come forward with some evidence of a triable issue. It's not enough just to say there's an issue. And there's no record of it. Your client didn't put in the expert's affidavit at that point, didn't put in any other evidence. So we have a burden issue here that I think would be good for you to address.
Yes, Your Honor. And the first burden that the defense was supposed to establish is whether or not, with clear and convincing evidence, there was an issue of material fact. And as Your Honor mentioned, the motion for summary judgment was based on the testimony of the plaintiff only. And within that testimony, there are genuine issues of material fact, because yes, during the deposition, there were, I would call it legal gymnastics. They show them a picture of the stairs and they said, well, there's nothing stopping the view of their stairs. Did you trip on anything with the stairs? Was there something wrong with the stairs? And the fact is these stairs were behind a closed door. Again, a change in level.
And there was a landing. Your client authenticated photographs that showed a landing behind that door and that they were marked with caution tape. and she didn't slip on a transitory substance. And I think the trial judge expressly found that her, if not in the order on the record at the hearing, that this just boiled down to she didn't, the only evidence that he had was that she essentially wasn't using due care, which in these types of premises liability cases can be the end of the triable issue.
No, Your Honor. Actually, any determination of whether or not the plaintiff was exercising due care, that's actually a question of fact that should be determined by a jury and not a judge.
Well, have you read the Brookie case out of the First District?
I've read lots of cases, Your Honor. I'm not
So
familiar.
it's cited in one or the other of your all's briefs, maybe both. And essentially what that case says is when the proprietor is entitled to assume that an invitee will perceive obvious dangers. There's no duty to warn against obvious and open dangers. And business owners aren't universal insurers. Using due care to navigate, obvious hazards like marked stairs, that's on the plaintiff. So I'd like you to address that.
Yes, Your Honor. Again, it comes into whether or not these are obvious hazards. Again, in this case, this is not open and obvious. These stairs
Well, and that hinges entirely on the fact that they're behind a door. I'm sorry.
it can, Your Honor. That's definitely one big factor. It's whether it's open and obvious and it's behind a closed door. It's by definition.
Well, when you open the door, it's obvious.
No, Your Honor. Again, that's where there is a, from picture of 405 of the record, if one looks at the door and the measurement of the door and the first step, there are genuine issues of material fact whether or not that is enough. And that comes into the industry standards. Industry standards says,
Which were not before the trial court at the motion for summary judgment.
yes, Your Honor, at that time it was not. However, it did come forward in the motion for rehearing and the Florida.
At which point the trial court had discretion and your client offered no explanation or any exigent circumstances, which is what the case law suggests is appropriate to be entitled to consideration of after the fact evidence, that there's no reason why this expert couldn't have ginned that up in time for the summary judgment hearing. So speak to that.
Well, Your Honors, first, the order denying the rehearing was entered the very next day once the plaintiff filed the motion. So the plaintiff did not have an opportunity to clear any issues in front of the judge. And that is a big point.
What? Say that again?
The motion for rehearing was entered, I believe, on the December 3rd. On December 4th, just the very next day, the judge entered an order. There was not a hearing on the motion for rehearing. And that we are saying that is an abuse of discretion because the plaintiff did not get an opportunity to explain.
Wait, it's an abuse of discretion not to conduct a hearing on a motion for rehearing?
Depending on the circumstances, just like this court determined in Fatherly versus California Bank.
You didn't argue that in the briefs, though. I mean, to the extent you felt like you should have gotten a hearing on the motion for rehearing, which itself is a discretionary decision, has that been argued? I don't remember seeing that in the briefs. Did I miss something?
Yes, Your Honor. In fact, the Fatherly case is stated in the reply brief as that was part of the discussion and the answer brief that needed to be addressed. And it was
But you didn't argue it in your initial brief?
Yes, Your Honor, that it is our second point on whether or not we were given an opportunity, whether the affidavit should have been taken into account.
What? But you're talking
That's
about
a
two
different
things.
issue than whether or not the court should have conducted a hearing, isn't it? Aren't those two separate issues?
It is two separate issues, Your Honor, and it is addressed in the initial brief as well. And it comes down to, just like this court did in Fatherly versus California Bank. In that case, it was a foreclosure case. The motion for summary judgment was granted. A bank brings a case against the defendant that in this case is a homeowner. And the issue is whether or not they're making payments. They're not making payments, foreclosure is allowed. That was granted on summary judgment. Then on a motion for rehearing, there's evidence to show that the homeowner was actually making payments to the bank. But the trial court did not give that homeowner an opportunity to be heard. They're not taking the evidence into account, and not taking the evidence into account that absolutely defeats summary judgment.
Well, back up the truck for a minute. You file the motion for rehearing, and with it, you submit this expert's affidavit, but your motion for rehearing doesn't provide any explanation for why the expert's affidavit is being submitted for the very first time, a year after the motion for summary judgment was filed. And that's where I think the wheels fall off of your abuse of discretion argument relative to this trial judge and how he treated it.
Well, Your Honor, the timing has not been an issue, and we understand that summary judgment has recently changed and specifically allows when evidence needs to be put forward. But
Well, the summary judgment rule requires evidence to be in 2 days, the old summary judgment rule, 2 days before the hearing. And here we're talking, a long time after the motion was filed and at least several weeks after the hearing occurred. And the law bound you as the proponent of that late evidence to explain what the exigent circumstances warranting its consideration after the decision was, but your motion doesn't do that.
Well, Your Honor, again, it still created a genuine issue of material fact. And just like this court determined, as long as there is a genuine issue of material fact and there's conflict in the evidence, summary judgment is not appropriate. And that's what happened here. It's not about the timing, it's the fact that the evidence was brought up at all. And that again, that can raise the level of an abuse of discretion standard, just like this court determined in Fatherly versus California Bank. But even bringing up back to the first point, just looking at the defense itself, it was the defense that had the standard of proving there's no genuine issue of material fact. And again, it all relies on the testimony of our client and the pictures. The pictures still show there is a gap in timing when one opens the door and one expects the stairs to encounter the stairs. This isn't a case like Ramsey versus Home Depot that the appellee relies on. And in that case, we're dealing with wheel stops in a parking lot. Wheel stops are what stops each at a parking lot, each car at a parking lot. They're all over the parking lot. That's a case where it's open and obvious. Yeah, it's a dangerous condition. Any raise in floor levels that causes anyone to trip and suffer injuries, as it was in this case, that's a dangerous condition, but then it relies on whether or not it's open and obvious. I'll agree. A wheel stop in the middle of a parking lot, that's open and obvious. In that case, there's no dispute in that case. In this case, we're not dealing with wheel stops in the middle of the parking lot. We're dealing with stairs behind a closed door.
I think, Mr. Sierra, I think this is where I think the problem that we have is that looking at the record before summary judgment is that, and it goes back to my very first initial question to you, what evidence was presented in any way that the stairs were defective? You keep saying, well, they were behind hidden. There was no evidence that they were hidden. If you look at the photograph, it indicated that the door opened, there was a landing, there was, so it didn't immediately drop off the door. The stairs were textured, and that's apparently to prevent slipping. The stairs were painted partially yellow to make it more obvious and visible. There was even a handrail.
There's a handrail.
Follows the angle to show that. So, and your client even admitted there was nothing blocking her view of the steps. So I go back to my initial question, what evidence that you have in any way that the stairs were defective?
May I respond? I see my time is about to expire.
You're fine, Mr. Chair. You still have a couple of minutes before your rebuttal.
Yeah, thank you, Your Honor. The evidence is still whether it's, again, it's behind the closed door. And then when one opens the door is the timing of how long does one have before the first step. I agree, there's a rail there.
There's no dispute that it was lighted, right?
Well, Your Honor, from the picture itself, there's just one light hanging from it. I would argue there is dispute as to whether or not that lighting is enough just from the pictures alone. and whether or not one expects to encounter steps down at a public restroom. This is Florida, where we're not.
At
No,
least you admit that it was illuminated to some extent.
there was a light there, yes, Your Honor. However, the expectations, the fact that this door on page 406, it said restroom and other advertisement, but it did not say, careful, you're about to encounter stairs. That creates a genuine issue of material fact. And the fact that the trial court said she wasn't paying attention, that right there is a factual determination that should have been determined by a jury, not a judge. And this court should reverse.
Mr. Sierra, you're right now ready for you're going into your rebuttal. So if you'd like to reserve the rest for rebuttal, I'll give you that time. Okay.
Thank
Very
you.
good. All right. And can I trouble you to mute your microphone, Mr. Spinner, if you're ready to come forward? And if you could unmute your microphone, the court is ready for your response.
Thank you, Madam Chief Judge, and may it please the court. Samuel Spinner on behalf of the appellee in this case, Pokies Incorporated. Pokies respectfully request that this court affirm the final summary judgment in its favor because the trial court correctly determined that the subject stairs did not amount to a dangerous condition and therefore did not give rise to a breach of either of the duties that Pokies owed Ms. Strandberg as an invitee on its premises as a matter of law. And really, we should start there, as you noted, Madam Chief Judge, that the parties agree that the law is settled that a routine change in elevation, stairs, steps, things of that nature are not considered dangerous conditions in Florida. To your point, Judge LaGritte, we're also not talking about a transitory foreign substance. We're not talking about debris on the stairs that are in disrepair or negligently maintained. The sole question in this case is whether the appellant established an exception to the general rule once the burden was tendered to her on summary judgment after we met our initial burden to establish that the stairs fell under the general rule of no liability. And the trial court correctly determined that the appellant failed to meet that counter burden. Specifically, the case law has developed two exceptions to the general rule of no liability. One where the condition is uncommonly designed and or substantially violates the building code. And second, when the layout of the condition and surrounding circumstances creates an optical illusion such that the plaintiff is not able to readily discern that there's a difference in floor level. And in this case, as the court has noted, the sole evidence presented was Ms. Strandberg's testimony, and her testimony did not establish either of those exceptions. It's really just been argument of counsel as to what the photographs show, whereas the appellant herself stated, quote, "I didn't see the steps, I fell down the steps, that's all I can tell you, it happened very quickly." And that's what the trial court found. So when it commented on appellant's, the belief that the appellant was simply not paying attention, that wasn't the court making a finding as to comparative fault. It was simply commenting on the appellant's own testimony as to what she was doing at the time. And the plaintiff has relied, or the appellant's relied on some cases talking about, there might be circumstances where the condition creates a distraction or a diversion away from the condition such that the plaintiff can't notice it. But there's a difference between a diversion caused by the condition and the plaintiff's mere inattentiveness in encountering a condition. And the trial court determined that this case clearly falls under the latter because there was no explanation. The plaintiff's not the one who said, well, that it was hidden behind a door and it was dangerous or an optical illusion. All she said was, I was going to the bathroom, I hadn't been here before, I didn't realize there were stairs, and I fell. There's also no evidence of any prior accidents on this premises. I think it's important to keep in mind, we're talking about a bar in the heart of downtown Tampa that countless patrons use day in and day out, and there's no evidence that Pokies received as much as a complaint regarding these stairs, much less a prior accident that would give it actual or constructive knowledge of a dangerous condition on its premises. And I think it's important to keep that in mind because sometimes in these cases, I think it tends to get lost that we're not just talking about whether there was a dangerous condition. There still has to be knowledge of the dangerous condition as a prerequisite for the defendant to be found liable under a breach of either of its duties. And so even if there was any dispute as to whether these steps amounted to a dangerous condition, which they do not, there's also no evidence establishing that Pokies, which is a tenant at this building, had actual or constructive knowledge because there was no prior accidents on record. All we have is the appellant's testimony. Additionally, Your Honors, appellant's counsel is correct that we're dealing with two standards of review when we're talking about the late filed affidavit of their expert. I believe that the facts of this case are a complete non-starter in getting to reviewing the counter affidavit, because this court would have to find that the trial court abused its discretion in denying to consider it before it can get to the issue of whether the affidavit was sufficient to create an issue of material fact. The plaintiff has relied on the Fatherly case, which is probably the most extraneous and unique exception that has been applied. It appears from that opinion that the court was really faulting counsel for not providing the evidence and felt bad that a woman was being foreclosed on, despite evidence that she had been making payments, because counsel failed to provide them. In this case, we had 8 months, just shy of 8 months between the MSJ and the hearing. And as the court stated specifically, Judge LaBritte, there was no explanation for why, or exigent circumstances for why this affidavit was late filed. This was really a classic example of the plaintiff just letting it ride based on the evidence that we filed, and then deciding to make a legitimate effort to oppose the summary judgment only after it had been entered. And I think the case law specifically discourages parties from taking those tactics, because a summary judgment hearing, a final summary judgment hearing, is really the most important hearing that can happen in a case that's not going to trial. And so I would submit that this court should also not encourage parties to take this conscious approach to decide to hire an expert only after they lose a summary judgment hearing. And I also wanted to note that all this happened pre-pandemic. So we're not dealing with, I couldn't get an expert to go and inspect a restaurant under the circumstances, because all this happened in 2019 and the order was entered in 2020. And again, the affidavit that was set forth in our brief is procedurally and substantively defective. Primarily because Mr. Ford didn't attach the photos that he was reviewing, and he didn't physically inspect the premises, so we don't know exactly what he relied on in formulating his opinions. Additionally, counsel referenced that he said that there was a violation of industry standards, but Mr. Ford didn't identify what industry standards he was talking about. The standard jury instructions discuss that the industry standards, code regulations must be admitted into evidence, and they were not, because all we had was a vague reference to those. And so, Your Honors, I won't belabor the point. The trial court entered a detailed order. As you can see from the hearing transcript, it went through all the cases. It asked counsel over and over, show me where the appellant's testimony establishes an exception to the well-established rule of no liability for a routine change in elevation. The trial court correctly determined that there was no such testimony, and that this is simply a quintessential case of stairs that had no substance or dangerousness about them, but rather that the appellant was simply not paying attention when she encountered them. The trial court certainly did not abuse its discretion in declining to consider the late filed evidence for the first time on rehearing. And unless the court has any questions, we'll rely on our brief and request that the court affirm the final summary judgment in favor of Pokies in all respects.
Very good. Thank you, Mr. Spindler. I'm going to
Thank
ask you to please mute your microphone. And Mr. Sierra, you have 4 minutes for rebuttal, sir, okay?
Yes, Your Honor. I will start that the analysis of actual constructive notice doesn't apply in this case, that duty only applies to transitory objects. That's by statute. In the lower court, the defense argued open and obvious. So if it's open and obvious, then the actual or constructive notice analysis doesn't apply in this case. It all relies into whether or not these stairs were open and obvious, whether one expects them when C goes to a public restroom, when one expects them to go down. In this case, when there was a door with no warning of the stairs that she was about to encounter. Whether or not the affidavit, this attached to pictures or not, the affidavit from Clinton Ford stated that these were the stairs were against industry standards. He relied on his knowledge and his expertise. And according to the McNabb case, that is perfectly fine for an expert to do. The Royal Caribbean case specifically states that him attaching the pictures and the affidavits, not attaching those pictures, that is not fatal. This court should still follow the Fatherly versus California case that specifically states the fact that the evidence can defeat summary judgment, that right there can be an abuse of discretion. And that's what this court should follow in this case. It's not necessarily about the timing. It's the fact that evidence was brought up at all The Florida Rules of Civil Procedure allow new evidence to enter on a motion for rehearing, and that's what this court should follow in determining what's abuse and discretion. Even if it does not, looking at the evidence and more favorable to the plaintiff, looking at these pictures, we're not talking about a stadium where there's stairs and one expects to encounter stairs going up and down a stadium. We're talking about stairs behind a closed door. That is not open and obvious. A warning was required, and this court should reverse.
Very good. Thank you, sir. Thank you both. So at this time, I'm gonna ask you to please, if you could exit, we'll go ahead and call the third case at